Right now, the Supreme Court of Canada is hearing arguments regarding Quebec's infamous use of the Charter's notwithstanding clause, which is often referred to as a sunset clause, by the way, because usually when provinces use it, it's enforceable for up to 5 years. And we're hearing arguments regarding the controversial Bill 21, which was a bill that prevented um, religious symbols, so to speak, in public institutions,
Mhm.
in a nutshell.
Mhm.
Uh, the reason it's quite important right now in terms of constitutionally is because it's not just another lawsuit or another legal challenge, but it's actually a constitutional turning point, and we rarely have some of them pertaining to this issue. So the issue is basically regarding Section 33 of the Canadian Charter of Rights, right? Which allows provincial governments to sometimes override certain charter rights, right? Particularly Section 2 and 7 to 15. So oftentimes what the courts look, it goes through the court level processes. We call those forums, right? So it goes to the Superior Court and then it goes to the Court of Appeals and now it's at the Supreme Court level, right? The question that the justices often ask and ponder about and debate about after they've heard arguments is this power to enforce the notwithstanding clause to limit or override or circumvent certain charter rights absolute? Or can the court still do something to add more limitations about its usage? So, a little bit about uh, recent history in terms of the Constitution and its use of the notwithstanding clause. So in 1988, a landmark decision, Ford versus Quebec, was established, where the Supreme Court struck down a particular law where Quebec, we noticed Quebec immediately using it to override it. And that was the precedent judicially to establish an overriding model in politics. Fast forward to 10 years later, and the secession reference, so it's the secession of Quebec reference to the Supreme Court in 1998, which introduced principles like minority protections and democracy. And this was important because it established the foundation of 2 years later what we call the Clarity Act. It was when Jean Chrétien was the prime minister. Um, Basically, it established a precedent where we had to be much clearer with the questions we ask to voters during referenda, okay, or a referendum. And
Mhm.
then fast forward to Toronto versus Ontario, where you have the courts warning against using explicit texts in constitutional documents. Okay.
Mhm.
So here's the thing, the Constitution clearly allows Quebec to use it. And what the opinion of the Quebec government typically is that the courts should stay out of it. However, there's also a precedent where the legal system should impose protections of minorities, like the freedom of expression and religion, even from provincial legislatures. Okay. So, what are your two thoughts about this entire process, David? And what do you think is going to be the likely decision that the Supreme Court will come to? What are your thoughts, and what do you think the Supreme Court of Canada will end up ruling on
I have a
regarding
pretty
this?
good feeling that the Supreme Court is going to have a balanced take on this.
Mm,
The question of religious freedoms in this country are pretty enshrined in the Constitution. You get a sense that Quebec legislature felt that this was wrong anyway because they preemptively used the notwithstanding clause. They didn't actually use it to um, due to a court order. They preemptively set it up so that it would be shielded completely. So there is a case for contesting it and saying to the Supreme Court, this was not how the notwithstanding clause was designed. And if that does come up with the judges to rule on, then I have a pretty good feeling they're going to say, yeah, that's not how this was designed. You're using it as a weapon. But on the other hand, what's it there for if you're not allowed to use it? It's just that clear. And so I have my doubts. I think they're going to have a very balanced view,
Hmm.
but I'm very anxious to see what they come up with.
So I'm of the opinion that probably like 75% to 85% likelihood that they will uphold the validity of using the notwithstanding clause for provincial powers. Okay. And the reason being there's already a strong precedent for its use. And Section 2 is the freedom of religion, which is Bill 21's basis, right?
Yep.
And it can be enforced legally up to 5 years because of this clause, right?
Yep.
There's also so there is legitimacy in terms of its institutional
I get that, but it's being
matter.
challenged for a reason.
Yeah, yeah, but because it's infringing on religious freedoms, I get that. But here's the thing: the Supreme Court also has the power to make declaratory statements, okay, in its judgment. So they might say, okay, we can't overturn this, like we cannot strike this down, but at the same time, they're going to say things like Bill 21 does violate the charter rights, particularly the charter's freedom of religion rights
Yeah.
in Section 2. Okay.
I think
So,
that's the approach they're going to take because they've even had
yeah.
criticism from the United going all the way to the United Nations.
Yeah, well, also we have a much more progressive. We Our Supreme Court tends to evolve as society progresses. It's not like the originalist approach that the conservative justices have in American
Right,
history and currently on the
right,
Supreme Court of the United States. It's not the
right,
same.
right.
Um, Now, this basically isn't necessarily about Bill 21, but it's more about whether rights in Canada should be enforced by judges or negotiated through politics. I think that's also an interesting question to ask, given that, okay, the Supreme Court has to decide on this constitutional feature, or is
Hmm.
it actually constitutional caveat or a bug, right?